Courts in the United States are as complex and varied as the communities in which they operate. There are more than 30,000 judges across our state and federal courts, including about 2,500 federal judges. In this program, we will learn more about the job of judging, how judges get their jobs, the expectations and responsibilities of the judicial role, and the unique and complex judicial decision-making process. Federal judges are nominated by the President of the United States and approved by a majority vote of the U.S. Senate. As specified by the Constitution, federal judges remain in their jobs until they resign, retire, die, or are removed from office. Congress can impeach and remove a federal judge from office for misconduct or abuse of power, but it has only done so 15 times in our country's history. The last time was in 2010. State court judges get their jobs in a variety of ways. Depending on the state, judges may be appointed by a governor, approved by the legislature or a judicial commission, elected by popular vote, appointed or elected to a time-limited term, subject to a retention election, or some mix of several of these methods. Some states have nonpartisan judicial elections, and some have partisan judicial elections, which mean a judicial candidate's political party is listed on the ballot. Some states impose term limits and age limits on judges. In some states, judges can be removed from office by popular vote in a recall election. And all of these methods vary and can change frequently across the states. Legal scholars see benefits and costs in both judicial appointments and judicial elections. Some argue that appointments to long terms can help shield a judge from political pressures. Others argue that popular elections make judges more accountable to the communities they serve. Balancing a judge's ability to do his or her job without worrying about what's popular or politically beneficial with mechanisms for accountability is an ongoing experiment with no right or wrong answer. Once they have the job, all judges take an oath, like this one taken by federal judges. I do solemnly affirm that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me under the Constitution and laws of the United States. Once they take the oath, judges are given the authority and independence to make judgments in individual cases, within the constraints of law, rules, and ethics, and to make the decisions that are necessary to resolve cases. Faithfully and impartially discharging and performing all the duties of a judge is a lofty ideal, so there are some structures in place to help judges meet that ideal. Federal and state court judges are subject to codes of judicial conduct, which outline the ethical standards of the profession. For example, these codes often say that judges must act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and that judges must recuse or remove themselves from cases in which they appear to have a financial interest, conflict of interest, or cannot be impartial. These codes require judges to refrain from engaging in political activity or developing political or business relationships that could lead to biased judgments. Of course, the wording of these standards can mean different things to different people and may leave room for interpretation. To help interpret and apply these standards, most courts have a Judicial Conduct Commission that can provide guidance to judges on ethical behavior and investigate ethics complaints against judges. Judges who violate these codes may be subject to sanctions. Federal judges can be investigated and disciplined by their circuit's judicial council or the Judicial Conference of the United States, which is an administrative body made up of the chief judges of each federal circuit court and chaired by the Chief Justice of the United States. They can also be removed from office by Congress through impeachment proceedings in the House and conviction in the Senate. State court judges might be privately reprimanded, required to perform community service, publicly reprimanded, or forced to resign. Most states have mechanisms for impeaching judges, though this process is typically reserved for serious ethical and criminal violations. The oath of office, codes of conduct, and judicial conduct commissions work together to help judges develop shared values and to provide the public with a set of expectations for judicial behavior. The Supreme Court recently adopted its own code of conduct, which applies to the justices of the Supreme Court. It is nearly identical to the federal judicial code, but adapted to the unique needs of the highest court. One difference is the justices have a duty to sit. When a lower court judge recuses, another federal judge can take the recusing judge's place, but current law does not allow for a Supreme Court justice to be replaced. So if a justice recuses, the court might split its vote, with 4 justices on each side and no binding decision. Justice Antonin Scalia once said recusal is the same as casting a vote against the petitioner, or the party that appealed the case to the Supreme Court. Because if the court is divided, the decision of the lower court stands. But some believe that justices should recuse when there is the potential for bias, or even the appearance of bias, as a way to instill and retain public trust. The justices can and do recuse, but whether to do so is up to them. Another difference is enforcement. Neither the Federal Code of Conduct nor the Supreme Court Code is binding for Supreme Court justices. But the Federal Judicial Code does provide for disciplining a federal court judge who violates the Judicial Conduct and Disability Act, which was passed by Congress in 1980. That act created a process for complaints and discipline against judges who do something that threatens the effective and expeditious administration of the business of the courts, or aren't able to do their work for reasons of mental or physical disability. That process cannot be the basis for complaints against the Supreme Court justices, because the Act does not apply to the Supreme Court, and there are debates over whether the justices can be subject to discipline by lower court judges. While they are bound by the oath of office and codes of conduct, judges exercise broad discretion in their judicial decision-making. Judicial discretion refers to a judge's power to make a decision based on their own evaluation of the issues before them, guided by the principles of law. Given their unique roles and authority, judges approach decision-making in several unique ways. First, a judge's decision-making is constrained in formal and informal ways. Judges must ensure their decisions abide by sources of law, such as the U.S. Constitution, the state constitution, statutes and local ordinances, and case law and precedent. Judges also adhere to federal or state rules of practice and procedure, which govern the process by which cases are moved through the courts, and sentencing guidelines, which provide guidance for appropriate sentences for people convicted of certain crimes. Judges are further constrained by ethics, codes of conduct, traditions, and norms. Second, with few exceptions, judges must explain their rulings. Most federal judges write opinions that must articulate the facts and law supporting their decisions, and those written opinions must be made public. Sometimes judges even issue orders from the bench and personally explain to the courtroom their reasoning. Once a judge issues an order, their work may then be subject to review through the appellate process if a party believes the judge abused their discretion or made an error of law. If a judge does make a mistake, either in law or in procedure, the decision might be overturned by a higher court. Finally, judges' decisions can have an impact far beyond a single case. Their decisions, especially those that are issued formally in written opinions, become part of our common law system. In a common law system, judges consider prior decisions made in similar cases to help create consistent and predictable outcomes. This means a case from long ago or far away can influence cases right here and now. And a judge writing a decision today must consider how it might affect later cases. Appellate judges and Supreme Court justices face an additional constraint. They may only review the facts of the case as presented at trial or in a summary judgment, which is a court-ordered judgment that ends a case without a full trial. Appeals courts do not have juries. No new witnesses may be called, and no new evidence may be presented. Lawyers for both sides can submit briefs to summarize their positions and present oral arguments. But the job of the appeals court is to review the trial court's work to make sure the process was fair and there were no legal mistakes that affected the outcome. It is rare that all parties are happy with the outcome of a case. In an adversarial system, someone wins and someone loses. But we hope that all parties are heard, respected, and treated fairly. When the system is operating as intended, we can trust the judiciary to treat us fairly and to protect our constitutional rights to due process of the law, which guarantees all Americans the right to a fair trial. And when we see that the judicial system is striving to operate fairly and impartially, it's easier for us to accept judgments issued by courts, even when we disagree with them. Sentencing is one of the most challenging parts of being a judge. Many judges struggle with the responsibility of determining the appropriate punishment for a person who is convicted of a crime. Depriving someone of life and liberty is a difficult and weighty job. Sentencing also is a good illustration of the complexity of the judicial decision-making process. By law, a judge has the discretion to impose a sentence sufficient but not greater than necessary. Judges also must consider many factors identified by the federal sentencing statute. Those factors include the nature and circumstances of the offense, the history and circumstances of the defendant, the seriousness of the offense, the need to promote respect for the law among the public, the need to protect the public from further crimes by the defendant, and whether the sentence should include vocational training, education, or medical treatment. Sentencing guidelines may also be considered. Sentencing guidelines offer recommended sentences for specific crimes based on a calculation of factors such as the severity of the crime and the defendant's criminal history. Most federal sentencing guidelines are now considered advisory, meaning federal judges can consider the recommendations but do not have to use them. But the guidelines still offer a reference point for judges during the sentencing process. And in certain types of cases involving drug trafficking and firearms, mandatory minimum sentences may still apply. Many states have their own sentencing laws and guidelines to provide guidance to state court judges or to require mandatory minimum sentences for specific crimes. During a sentencing hearing, the judge may also hear from the defendant and the defendant's family and friends, and from the victim and the victim's family and friends. And then all of these factors must be carefully weighed as a judge determines a sentence. In an essay for Judicature, a magazine for judges, Judge Timothy Corrigan, a retired chief judge of the U.S. District Court for the Middle District of Florida, wrote in very personal terms about the weight of the sentencing responsibility. Here's some of what he wrote. After a particularly difficult sentencing, I often say, sometimes to myself, "Who appointed me God?" Or why did I possibly think I was the right person for this job? Or why did anyone possibly think I was the right person for this job? Of course, I know that sentencing judges are not God. We are mere mortals tasked with the sometimes impossible assignment of determining a sentence that is sufficient but not greater than necessary. But sentencing judges do have very wide discretion, and in all but a few cases, the decision of the sentencing judge is final. Judging is difficult and can be a solitary job. Not every judge gets it right every time. But we have a right to expect our judges to take their oaths seriously and to do their very best to administer justice without respect to persons. to do equal right to the poor and to the rich, and to faithfully and impartially discharge and perform all the duties we entrust to them. And as American citizens, it is our responsibility to hold judges accountable to these promises.